Good morning. This is Albert Chang, Chair of the New Mexico Oil Conservation Commission. It is just after 9 o'clock on August 13th of 2026. Welcome to a meeting of the Commission, our regular meeting for August 13th of 2026. Commission Clerk, Madam Clerk, may I please have the roll?
Yes, good morning. Commissioner Ampoma?
Present.
Commissioner Chang?
Present.
Commissioner Bloom?
Present.
Okay, we have a full quorum.
Thank you very much. We're all present and accounted for. So may I please have, or have commissioners had a chance to review the agenda, and is there a motion to approve?
Mr. Chair, yes, I would move to approve the agenda.
Mr. Chair, I will second.
Moved and seconded. Is there any objection from commissioners? Hearing no objection, the agenda is adopted. Next item on the agenda is the approval of the minutes. I understand that some commissioners may not have received them, and so I'm happy to entertain a motion to postpone.
Mr. Chair, I would move to postpone, please.
I second.
Any objections? Without objections from any commissioners, so ordered. Then we move on to pending cases. I'll call case number 26206, application of Marathon Oil Company for a de novo hearing.
Good morning, Paula Vance with the Santa Fe office of Holland and Hart on behalf of Marathon Oil Company.
Good morning, Mr. Commissioners. Ben Holliday appearing on behalf of Powderhorn Operating.
Okay. I think last we left off, the parties were going to discuss what your needs are, and we're going to try to schedule a hearing sooner rather than later, if possible. I'm happy to let you guys advise as to where you are on status and what your needs are for hearing.
I'll go ahead, Ben, if you don't mind. So we have conferred, and I think we're pretty much there on putting together a draft pre-hearing order that will be similar to what the commission saw with the Coterra and Permian case. Was it this year? Sorry, I can't remember when we did that, but a similar pre-hearing order. That being said, the only point of that we haven't been able to agree on is the timing. Marathon will have 3 witnesses, and we've as far as when they will be available, the soonest availability that all 3 of our witnesses will be able to be at the hearing would be October 19th through October 20th. And we do anticipate that being a 2-day hearing for this. And I'll let Mr. Holliday take it from there.
Okay, Mr. Holliday?
Yes, I agree that we are there on the pre-hearing order. I just want to provide a little context for Powderhorn's perspective on why that date is not optimal for us. And this case was originally filed in September of last year, and so if we push this out to mid-October, we're looking at well over a year from the date the case was filed, and it's going to be close to 170 days from the date the original order was issued, right? And so, from Powderhorn's perspective, Marathon has stated that this is a priority and they needed to have a stay to prevent us from drilling because they intend to go develop. And we don't think it's either fair or reasonable for a company of that size to only have 2 or 3 witnesses that could participate. That then forces us to kick this down the road another 60 days. So Powderhorn would ask that we set that hearing in sometime in September, but we'll leave that to the commission's discretion.
I appreciate that. Let me back up for a second and ask both parties, do either one of you anticipate any sort of pretrial motions practice, partial summary judgment motions? Do either one of you anticipate any of that?
From Marathon's perspective, no.
Okay.
Same for Powderhorn. No, sir. Do not anticipate.
Okay. I guess it comes down to witness availability, right? So.
Right, and I'm happy to respond to Mr. Holliday's presentation there. This case was actually filed at the end of May. So this de novo application, I think Mr. Holliday is referring to the division
yeah.
application, but this particular application was filed only recently. And although, Marathon is a big company, but we want to have our witnesses available who are familiar with these lands, with this development, and these are the available dates that we have, the soonest available dates. And we want to be able to have our witnesses here and in person to be able to answer questions of the commission. This is an important development project for Marathon, and so I would just ask that we be able to set a hearing date that allows us to have all of our witnesses at the hearing. So.
And these 3 witnesses are all employees of Marathon?
That's correct.
Okay. And how many witnesses are you presenting, Mr. Holliday? Also 3?
Yes, sir. We'll have anticipate having the same 3 as in the underlying hearing.
Okay. I certainly appreciate the desire to have witnesses here in person, but we've had witnesses participate via the platform before. So if that assists Marathon in any way, that certainly is not the end of the world. We are still able to ask witnesses questions. Part of this will also come down to commissioner availability. So I will have to see when the commissioners are available. But what I'm hearing is, Mr. Holliday, you've asked for September hearing dates, and Marathon has asked for October hearing dates.
October hearing dates. And I would just say that is the first available dates where all of our witnesses are available at the same time. All of our witnesses up to that point have prior obligations and commitments, and so will not be available prior to that. So again, I just would push that we set something that will allow us to have all of our, to Mr. Holliday's point, he wants to have his 3 witnesses from the underlying case that was heard at the division level, and similarly, Marathon would like to have its witnesses, all 3 witnesses that participated at the division level, available for the de novo hearing.
I understand, but given that they're all of Marathon's own employees, I'll ask that Marathon try to reorganize their workload and schedule to the extent necessary to also accommodate, because we've got, yes, we will try to do our best to accommodate your witnesses, but we also need to accommodate commissioner schedules, and obviously Mr. Holliday's witnesses, I'm sure they also have other obligations to schedule around. So I'll ask Marathon to try to be somewhat flexible, and same to Powderhorn. We'll do our best we'll look at September and October, and we'll make sure that we try to schedule sometime within those 2 months, given that commissioner availability is also limited. So we'll do our best on our end. Speaking of commissioners, did you want to discuss your calendars right this very minute, or would it be more effective for us to coordinate through the commission clerk and issue and give them a decision on dates at a later time?
Mr. Chair, so I just want to point out that the last 2 weeks of October, I'm not available. So
Okay.
19th, the week of the 19th of October, the week of the 26th of October, I'm not available. But I'm available in September and also in November.
Pulling up my calendar now too. Commissioner Bloom, any thoughts on your availability?
Let me look here. Week of September 21st, Monday, September 21st works. Second week in October. Yeah, and then we're getting into November. Early November is fine.
Remind me what dates you wanted, Mr. Holliday, just any time in September, or did you say something more specific?
No, sir, anytime, I mean, anytime in September would be good for Powderhorn. If we were to hold it to that 14th through, 30th timeframe, that gives everybody, 30 days from now to prepare. But certainly anytime in September.
Yeah, I'm not available the week of the 14th, and
Me neither.
my first availability, and this is just for me, I don't know about the other two commissioners, but my first availability for 2 solid days would be Thursday and so the 24th and 25th of September. And then looking into early go ahead, Commissioner.
Yeah, yes, 24th, 25th would work for me of September.
That would really work best for me as well.
October 8th or 9th, or I could have make the October 15th and 16th work as well. So October 15th, we already have an OCC meeting.
Those dates would work for me as well, 15th, 16th.
15, 16 will work for me too.
Okay.
I'll just weigh in. I know we're pushing for early dates, and whatever dates work for you, we will accept and be flexible as well. I'm scheduled to be somewhere on the 15th and 16th, so we would prefer that earlier September slot, but if it ends up being the 15th, 16th, we can make that work as well.
Okay. And your current witness availability was what dates again for Marathon?
It was October 19th and 20th. And I do not believe that the September date will work.
19th and 20th. I'm sorry, October 19th and 20th?
Yes, that's correct.
But Dr. Mpoma is out.
Yeah, Dr. Mpoma's out and I'm out.
Are there November dates that would work?
Well, we did assure Powderhorn when we issued the stay that we try to be speedy on this. So I want to try to respect their needs as much as I can. I think instead of having us do this all here live, I'll ask the commission clerk to put together proposed dates and then give both parties an opportunity to confer with witnesses to figure out what what your respective witnesses can do and what would be the least disruptive to their workflows and also council availability.
That works for us. Thank you, Chair.
Okay. Well, we'll do our best to try to accommodate everybody's needs or probably compromise to nobody's full satisfaction, but we'll do our best here. And we'll have our commission clerk reach out to both parties shortly with available dates.
Thank you, Mr. Chair.
Does that work, Mr. Holliday?
Yes, sir. Thank you, commissioners.
Awesome. Thank you. Appreciate it. Is there anything else on this particular case for today that you guys need to bring up or want to discuss or need?
I don't have anything. Separately, I think Mr. Holliday and I will work on the pre-hearing order and submit that to the commission when it's ready. But I'm assuming we'll submit that after we've agreed on some dates for the hearing.
Okay.
Thank you.
Nothing
thank
further
you.
from Powderhorn.
Awesome. Thank you. Appreciate it. Thank you all very much. In that case, I will move on to case number 24683, which are the for commission consideration of the motions for rehearing. We've all gotten written briefings from all the parties, and thank you all for working on a very, very tight turnaround. The commission appreciates that. And we apologize that we are constrained by the 10-day calendar to if we were to take action. So, commissioners, I'll ask for your opinion. Do you need oral summations from the respective parties at this point, or are you ready to jump in with questions? What is more effective?
I'm open to listen and then ask questions afterwards. Thank you.
I'd be fine with that, Mr. Chair, and I have, yeah, some statements on, related to all of this. Thank you.
Okay. 5 minutes sufficient from all sides? 10? What's your pleasure?
No, I'm flexible.
Okay,
5 minutes each side?
that would be fine by me. If I could ask parties to just, well, I'll just speak for myself, but I know that I've certainly read all the written submissions and have reviewed them. So, but I'll, at the commission's request, if each party wants to give a brief summary of their positions on these applications for rehearing, we'll give you 5 minutes each. Commissioner, I'm sorry?
So are we combining both NIMOGA and IPNM all together?
Oh, I think so. I mean, unless you want to have arguments on them separately, but they seem to be closely related, and they are joined at least on one of those motions.
Yeah, I just wanted to clarify. So
Yeah.
Okay, thank you.
Okay. I will invite Mr. Suazo and Ms. Tripp. You're welcome to flip a coin as to who wants to start.
Ladies first, if that's good with you, Ann, but I'm also glad if you would like for me to start. I would actually just like to say, IPNM did join in NIMOGA's motion, but we did file them separately for a reason. So I'm not sure that it is appropriate to combine them, for these purposes. But I defer to the commission. I'm sure we can make that work.
Yes, that's fine. For clarity's sake, if you would like to take them up one at a time, we can certainly do that. Do parties, councils have a preference on which matter we take first if we were to take them separately?
No preference, Chair.
Okay. Well, since IPNM's was filed first, why don't we start with that?
All right. Thank you, Chair. This is Ann Tripp, and with me is Drew Cloutier. We're here on behalf of the Independent Petroleum Association of New Mexico. If I could have, I just made a few slides to summarize here, so I'm going to attempt to share. So you should be seeing this is so IPNM has applied for rehearing pursuant to section 70-2-25A. It is our position as outlined in the reply that pursuing application for rehearing is a separate standalone request for relief from section 70-2-12.2, allowing for appeal of a rulemaking to the New Mexico Court of Appeals. IPNM has requested rehearing on some discrete grounds. They are somewhat more general concerns that were raised throughout the rulemaking process and deliberations, as opposed to the more discrete technical or typographical issues that we've addressed earlier. Those three concerns arise from the fact that the purpose of a statement of reasons is to provide a concise explanatory statement, which then affords reviewing court the ability to review the commission's independent judgment and analysis, that winnowing and sifting of evidence, of witness testimony, and of policy decisions, frankly. And so in order to afford that meaningful judicial review, especially where there's been a stark departure from prior policy or interpretation or application of a statute or regulation, that reasoning becomes all the more important. And so IPNM's application for rehearing here is really based and rooted in that fundamental requirement for a statement of reasons. Here, the rulemaking order has adopted applicants' findings and arguments, and it's one conclusion, with the exception of those 5 identified paragraphs. And with that, there is a whole, laundry list, or maybe, laundry bucket of findings that may not be relevant or pertinent to the changes that were adopted. It's the form of the rulemaking order is somewhat distinct from prior decisions from the commission. I think at one point the comment was made, we did take advantage of the opportunity to file 75 pages of findings, but the commission was left with the option to either adopt one or write its own. And I think here that confuses the issue and really overlooks, why this change is needed, or explaining at least to the public and to the reviewing court why the change is needed, and why adopting increased financial assurance in addition to the other changes is going to diminish orphan wells when all those orphan wells had bonds at the time that they were orphaned. A second ground that we've asked for application for rehearing is the contradictory position expressed on prevention of waste. Here within the rulemaking order, and as we heard in questioning and testimony, the premature plugging of wells creates waste, especially with TA wells or with any low producing well. And so if plugging one well creates waste, then plugging other wells also creates waste. There's some contradictory logic or reasoning there that we think requires review by the commission. Additionally, putting waste in context, we heard that applicants have relied on leaking methane from wells. Using the evidence that's in the record regards with the EPA study and the Legislative Finance Committee report, to put that waste in context and in scale, the leaking methane averages, using the highest averages and the greatest rates of leak, is 0.002% of the waste or in volume compared to current 2024 production for gas and oil wells. And so here, in addition to some of the concerns with procedural irregularities, a fundamental issue is whether this rule addresses just legacy abandonment and reclamation and remediation issues, and putting secondary and tertiary recovery, sacrificing that on the altar of solving a problem now rather than looking forward. Because it's established and it's undisputed, secondary and tertiary recovery can account for 60 to 70% of recovery of hydrocarbons in the reservoir. And so to the extent that you plug viable access to those reservoirs now, that affects operators, and you heard from Oxy's witnesses as well as IPNMs and NMOGAs, that affects how operators move from this great boom in primary production with shale fracking onto those secondary and tertiary phases in the next 10 to 20 years. Finally, additional grounds that we raised in our application with respect to the procedure, from our perspective, observing deliberations, it appeared that because IPNM did not re-propose the original rule, that was not considered as an alternative. And under the rulemaking regulations for the commission, there's the opportunity to adopt, reject, or amend. And so it was our perspective that it appeared when the commission moved through each of the changes, there wasn't necessarily a pause or explained on the record why the commission was moving forward with that change rather than just rejecting changes and continuing the same rule. One final point, and I'm most likely over my 5 minutes, but I think throughout this entire rulemaking, which we admit, 3 weeks of hearing, 32 witnesses, 5,000 pages of transcript alone, and we understand that is a huge amount of information to process. However, one piece of information that has not been communicated to the commission, which I think is important, is what is the ultimate price tag of these rule changes. We've not heard that the surety industry or the market can support it. We've not heard a final price tag of how much more financial assurance will need to be obtained. And we've not heard, we've not seen an economic analysis like you would see with legislation, which considers the man hours and the administrative burden that the rules will create. And so for those reasons, we respectfully request the commission adopt or grant our application for rehearing in addition to reopening the record for limited economic testimony. Thank you.
Mr. Suazo, would you like to comment on IPNM's application?
I don't have any comment on IPNM's application, but I'm glad to kind of go over a few of the points that I think might be further developed based upon NMOGA's application for rehearing, if you'd like for me to proceed with that.
I think we heard from Ms. Tripp that we'd prefer to take these separately one at a time. So if you don't have, I'll invite you to comment at this time on IPNM's application for rehearing, but if you don't have any, that's fine as well.
Sure. I mean, the only comment would be that we're generally supportive of IPNM's positions in their request for rehearing.
Okay, thank you. I'll turn to Welk then.
Thank you, Commission. I realize I'm in the room. In a nod towards efficiency, we filed joint responses with the division for both IPA&M and NMOGA's motions. And Mr. Nykiel, who should be on the platform, will offer our response for IPA&M.
Thank you. Mr. Nykiel.
Good morning, Chair and Commissioners. Thank you. My name is Matt Nykiel. I'm an attorney with the Western Environmental Law Center here on behalf of applicants. I'll just say briefly that the Commission clearly was impartial and exercised its independent judgment in issuing its rulemaking order. The Commission heard overwhelming technical evidence brought forward by applicants that supports the rules the Commission adopted. The Commission also heard fulsome technical and practical evidence from OCD's witnesses based on their years of regulatory experience and OCD collected industry data. In this case, industry would like a different outcome, but they by and large failed to offer hard data supporting their positions, failed to dispute applicants' data, and failed to offer policy proposals to address the orphan well crisis, which is the reason why these rules are needed and a reason that the Commission clearly addressed in its reasons supporting the adopted rules. Despite IPA&M's claims in their application for rehearing, the Commission is not required to respond to all concerns raised during a rulemaking hearing, particularly when they're not grounded in data. The reasons the Commission provided supporting its rulemaking order show the adopted rules are supported by substantial evidence and are sufficient to support its decision. The Commission should deny IPA&M's application for rehearing, and we respectfully request the Commission do so. Thank you.
Thank you. OCD.
Yes, Michael Hall here on behalf of OCD. I would join in those statements and just sort of to piggyback off evidence or lack thereof. Any evidence that's not in the record was because a party chose not to put it in the record. To now, after all this time of negotiating and presenting the parties' respective cases in the rulemaking, to now want to reopen this matter after all that time, all that effort is, in our opinion, just a delay tactic. Thank you.
Oxy.
Oxy's not taking a position. We're just monitoring at this point. Thank you.
State Land Office or any other party? EOG? Anybody else? Okay. In that case, I will turn to Commissioner for questions on IPA&M's application.
Chair, if you'll allow me, I don't have so much of a question, but I would like to go through some of what I saw in IPA&M's petition or motion to rehear. I found that essentially all the major issues that we dealt with during the hearing were brought up in a way that made it sound as if, or was colored as if, we had not addressed those things. So I'd like to go through and address a number of these things one by one, if you'll indulge me.
Sure.
Thank you. And at the outset, I'd like to note that before addressing IPA&M, we did hear we did look at the applicant's motion to rehear last week, and it was largely related to clerical errors. We dealt with those a week ago today. The applicants wanted to add one new sentence to the rule to underscore an aspect of bonding, but the Commission elected not to take that up, believing that the rule as it stands was sufficient. So looking at IPA&M's motion to rehear, we see that IPA&M cautions the Commission on page 3 of its motion that, quote, New Mexico's courts consistently disfavor and caution against wholesale adoption of one party's findings and conclusions where statutes mandate that an agency or commission exercise its own independent judgment. Well, this Commission did not do that. There was not wholesale adoption, as I'll outline in a moment. IPA&M then goes on to list its 5 reasons why there should be a rehearing. Numbers 1 and 4 were, quote, the Commission's refusal to consider and reject contrary evidence and party positions to include public comment. And 4, quote, rejection of proffered economic evidence, end quote. And my reply to these assertions is that the OCC clearly considered and judged all sides' testimony and positions, including IPNM's economic evidence. Had we not done so, the Commission would not have rejected parts of the applicant's proposal and created protections for industry in line with requests and the positions of IPNM, NMOGA, and OCC. Further, the OCC absolutely did not wholesale adopt the applicant's positions, and this is in large part due to what we heard from IPNM, NMOGA, and OCC. To refresh everyone's memories as to some of the times that the OCC differed or broke with the applicants and OCD's positions. Number one, the OCC took particular care to make sure that a well would not be bonded multiple times, i.e. we wanted to prevent stacking of bonds. This appears in 1915-8-9. That was important to industry. The OCC is not requiring bonding of wells and approved TA wells for approved TA wells during the first 2 years. That's 1915-8-9F. Dr. Mpoma flagged this pretty early in the evidentiary hearing, and I would say that he fought for that. And by the end, all 3 of the commissioners agreed with him on that. The OCC created a variance process for when wells must be bonded due to inactivity, with the variance being related to physical impediment to production, things like transportation line being down for natural gas, safety issues. That's 1915-8-9D3. Furthermore, number 4, the OCC is not requiring, as the applicants requested, newspaper publication for extension of temporary abandonment status at 1915-2513C. I believe OCC pushed for that, and then OCC also pushed for more restrictive language with respect to who can participate in the process for extension of temporary abandonment status. The applicants wanted any interested person, but the OCC adopted on a split vote that it had to be a person with standing. So those are just a few examples of that there was not wholesale adoption of one side's positions here. I believe, I'll note again during the evidentiary hearing that IPNM and NMOGA did not offer alternatives to the applicant's proposals. I said this early in the hearing and more than once. Instead, IPNM and NMOGA's case were focused really on opposing the applicant's positions. Once we were convinced, apparently, of the applicant's position that action needed to be taken on bonding and change of operator, there were not alternatives really from NMOGA and IPM to look at. I believe myself and certainly I believe my fellow commissioners as well were convinced by the applicants, clearly. That's where we came down, who cited many measures, statistics, and data showing the threat to the state from unplugged wells. We saw the Center for Applied Research study of lands in New Mexico that points out that there were about $200 million in bonds to cover liabilities. It would be, today, probably, I think then it was $8 billion, probably $10 billion now, so roughly 2%. This would be equivalent of allowing somebody to put $1 million of liability on land and insuring it with a $20,000 bond. There were some, I think I'm going to scoot over this point. On page 5, IPNM states that in addition, quote, in addition, neither during the hearing nor in deliberations did the commission consider at any time the ability of the Oil Conservation Division to actually implement the rule changes or the projected cost in man hours or full-time positions that the new rules will impose on OCD personnel. And that these 2 practical considerations are commonly performed with legislative changes. I'll note again, as I said a number of times throughout the case, that we're not the legislative body, we're not the LFC. This case, it's case 24683. The 24 means this case began in 2024. There were 2 legislative sessions when the legislature could have spoken on this issue of bonding and change of operator. It passed a law to prevent any of it. It did not. The applicants, of course, have the right to petition the OCC. The OCD was a party to this proceeding, and it is supportive of the applicant's position, and Mr. Tremaine addressed this in his August 11th reply to NMOGA's application to rehear. Regarding IPNM's other 3 criticisms, we see, quote, the commission's acceptance that premature plugging creates waste, yet finding that adoption of the applicant's proposed rules comports with the Commission's statutory mandates of the Oil and Gas Act. I do not recall the Commission accepting, quote, that premature plugging creates waste. Again, we spent a lot of time on this during the hearing. I'll go over some of my previous statements. That's that the OCC has the legal authority and a duty to make rules that prevent waste and protect public health and the environment. We did that in this case. The rulemaking falls within the statutory jurisdiction of the OCC. We heard that older wells, and particularly orphan wells, leak methane, which is a waste of the resource and a threat to human health and the environment. OCD's closing statement notes that, quote, over 60% of the orphan wells plugged by OCD cause waste by leaking natural gas. Even in wells and approved TA that have met mechanical integrity testing requirements and OCC rules can nonetheless emit and leak natural gas because equipment can fail over time, end quote. The applicant's closing argument notes on page 17 that, quote, the U.S. Environmental Protection Agency estimates that an average low or non-producing oil well leaks 1.8 tons of methane into the atmosphere each year, end quote. Mr. Powell of the OCD reminded us on page 16 of the OCD's closing that the legislature also gave the OCD jurisdiction over reclamation. Quote, it is also the OCD's job to manage the reclamation fund and to use available fund to plug orphaned wells. End quote. He goes on to say, quote, OCD also has the obligation to regulate and require the remediation of releases and environmental contamination, end quote. The legislature and law have clearly given the OCC authority over bonding. The applicant's closing arguments, pages 16 to 20, there are 5 pages that go on about prevention of waste. I don't want to read all of that, but on page, one of the paragraphs is, quote, applicants' FA proposals, financial assurance proposals, which increase bonding for high-risk wells and high-risk portfolios, nowhere require an operator to plug a well. Increasing bonding for these wells better reflects the actual costs to OCD, to P&A, and it's necessary to stem the tide of orphaned wells. If an operator is financially unable to internalize legitimate costs of doing business, the operator can transfer the well to a viable operator who can, end quote. The applicants go on to remind us that wells are routinely plugged in order to be plugged with hydrocarbons still in the ground. It's not economical or even realistic to produce every molecule of hydrocarbon that a well can access. This is discussed in the applicant's closing statement on page 17, where we saw, they're reminded that an IPA witness admitted as much. It was Mr. Ezel, I believe. So we should put any waste arguments in context as well, which the applicant's witness, Mr. Purvis, does. In the closing arguments from the applicant's page 17, he said, quote, he modeled the extent to which wells in New Mexico would be categorized as low producing wells subject to a single financial assurance. He found 3,900 wells would qualify, representing 6.6% of the statewide well population and only 0.048% of total statewide production, end quote. Again, that's 6.6 of wells, not even producing 0.05 of 1% of oil in the states. That's really stunning. Finally, on this point regarding waste, I note the applicant's proposal does not require P&A of wells, but rather that a class of wells be bonded. Operators can decide when it makes sense to P&A versus continuing to eke out low production and maintain a bond. I asked Mr. Purvis, this is about page 739 of the applicant's pre-hearing statement, about concerns from NMOGA and IPNM about companies being driven out of business by these proposed rules. I asked him for his conclusions from 2 2019 studies, Boomhauer and Lagan-Redlinger, that looked at impacts on production from increased regulation. Mr. Purvis said the studies concluded that there were only, quote, minor impacts on land produced for oil and gas, but environmental violations go down, end quote. Both IPNM and NMOGA bring up HB 80. I think we addressed this extensively during the hearing, and the hearing officer asked us about that as well. Again, with HB 80, we find that money is not held in an untouchable, irrevocable trust or permanent fund. I'd note that, and I think I expressed this earlier, that given the dependence of the state's budget on oil and gas, or somewhere between the third and a half of the budget comes from oil and gas, the need to sweep funds from a fund like the Reclamation Fund will happen when the state's struggling, because oil and gas industry is struggling. So during a time when the oil and gas industry would at least be able to plug wells, the state would be struggling to potentially sweep those funds. And I think we remember a day when the legislature was sweeping $10,000 sums a few years ago, and a decade ago, and we had furloughed employees. Again, there was talk in IPNM and NMOGA's motions for rehearing, applications for rehearing, looking at talking about 72-14 NMSA, and saying that it forbids new category of bonds. Again, the legislature had at least 2 sessions during which this case was underway to have addressed that very thing. It did not choose to act. Wrapping up here. IPNM goes on to state in its application for a hearing that in the process there is, I think this is their, a failure to afford temporarily abandoned wells required protection. The record will speak for itself on this, but the rule does not run askance of 70-2-14. This is addressed in the applicant's closing and in their and OCD's replies to IPNM and NMOGA's application and motions to rehear. Finally, IPNM asked for a rehearing because his 5th reason was, quote, confusion and procedural irregularities in the deliberations which constrain or prevents meaningful judicial review. With respect to confusion, this was a complex multi-party rulemaking. There were over 200 documents. I believe IPNM had 16 witnesses alone. At one point, I believe there were 8,000 pages of material. It might be over 10,000 pages now. There was a lot to administer here. Then after an evidentiary hearing, the parties got together and presented us, the OCC, with new language, which was what we largely adopted, minus the OCC examples that I cited earlier. As we explained at IPNM's request during deliberations, we referred to the document and language that came out of negotiations between the parties as the, quote, joint stipulation, end quote, for convenience sake. We then, and this is important, looked at the document and the time-consuming side-by-side comparison with IPNM's suggested language, NMOGA's suggested language, and Oxy's final suggested language. IPNM was heard, NMOGA was heard, Oxy was heard. This was represented in the many instances where we broke with the applicant's suggestions and rulemaking in cases. So this was clear, there was discussion, there was debate on the record, and a court could make a meaningful judicial review. That is it. Thank you, Mr. Chair, for indulging me.
Commissioner Mpomo.
Thank you, Commissioner Bloom. That was a very comprehensive presentation right there, and I'll concur with you on almost what you said. And I'm not sure if I can add, if I have any additional information to add, but one thing that I'll point out is, if I look at the number 4 issue that IPNM is raising here, rejection of preferred economic evidence on matter of public importance constitutes sufficient reasoning to grant rehearing. Now, as I read through that, they are making a case here that the commission more or less adapted the OCD cost and not really taking into account the industry cost. And even they went ahead to talk about the fact that OCD did not really consider the 95% that wells that the industry has plugged, the cost associated with that. Now, as I read through all of that, I will say that if you compare the evidence that the applicant and OCD presented with clear evidence, showing us that the conditions of the well doesn't really matter in here. As a petroleum engineer, when I was reviewing through those applications and even through the hearing, I had that same thought, like the depth of the well has to matter. How the well was completed, the age of the well needs to matter. But evidence was really presented here to convince me here as an engineer to really understand that we have to go with what OCD was presenting. So I felt like it was really thorough. And Commissioner Bloom pointed out, I fought really hard when it comes to some of the provisions that I feel like we need to really consider this. And he pointed all of that out. So with four days of deliberation, I feel like we did a really great job. And I mean, when I read through it, I do not see anything that stands out to me. So I'll concur with Commissioner Bloom's presentation, and that is the only thing that I will add to that. Thank you.
I'm going to take a slightly more limited, well, let's see if, so I do regret that IPNM feels that the commission refused or otherwise failed to sufficiently consider contrary evidence and other party positions. It certainly was not my intent to, well, I don't think I certainly did consider, and I'm sorry if that was not sufficiently communicated to all the parties so that they felt heard and they felt considered. Of course, understanding that the commission as a whole landed on a decision that was different than the one urged by IPNM and NMOGA, and to a certain extent, well, primarily adverse to the positions advocated by IPNM and NMOGA. I certainly tried my best throughout the deliberations and the hearings to signal and to make all parties, including IPNM and NMOGA, feel heard. And the commission understands its legal role, and we have a difference of opinion with some parties as to what constitutes waste and how waste is defined and how we have to handle that and how the duty to prevent waste intersects with the rule here. Certainly, I think the parties amongst themselves disagree as to whether or not the rule here functions to prevent waste or not. The commission had to make a decision, and I understand that the commission took a position that was not favorable to IPNM, or at least not a position that was urged by IPNM or NMOGA. But certainly we considered, I'll speak just for myself, I certainly did consider and read through all of the materials as hefty as the record was. We certainly did our very best to go through the record. I know that I insisted on going through, during deliberations, going through section by section, and of course, had commissioners felt like any sections should rest on the no change alternative, as IPNM noted here. It's certainly my understanding that that was always an option. It wasn't an option that was urged very frequently by fellow commissioners, but it certainly, speaking for only myself, I certainly understood that that was an option. In terms of whether the rules comport with the statute, again, that was briefed and argued multiple times. There was plenty of opportunities on House Bill 80 and whether or not to, we did reopen the record and took administrative notice of the passage of HB 80, what it did contain and what it didn't contain, what language was amended and what language wasn't amended. We did go through that. As to the decision not to reopen for additional witness testimony, I also recall, and I think the record will reflect, that I asked for a proffer of the evidence on multiple, I believe I asked for, I tried to clarify what the proffer was at least 3 times. So it was based on the decision on whether or not to reopen that record, to reopen for the purposes of additional witness testimony, was based on what the parties were able to present as part of that proffer. As to procedural allegations of procedural irregularity. I certainly hope not. I certainly hope that I certainly concede that I am human and fallible. However, we did try to go out of our way to consult with Commission Counsel when there was questions as to the sufficiency of the of any of the documents in front of us. So we certainly, at least let me speak only for myself. I certainly tried to be as clear on what processes and to be as deliberate and thoughtful on the procedures that we followed for this hearing. And most importantly, I think the most important question is when we're at this point, we're merely deciding not necessarily on the merits of the arguments that are being presented by IPNM, but the question of whether or not to reopen the hearing or to reopen or rehear anything at all, right? And to me, the most important concern here is whether or not the hearing was conducted in a way that allows for meaningful judicial review. Because I understand, of course, that this is a highly contentious policy rulemaking that has significant impacts and where there are stakeholders with strong concerns as well as stakeholders who are strongly in favor. And the legal issues raised, I think reasonable people can and did disagree on how best to interpret the statutes here. The commission was called on to make a decision, and certainly we want to make sure that we did so in a way that allows for meaningful judicial review. The record that we laid out, the briefings from all of the parties, the oral arguments, the transcript of the deliberations, I think, have allowed all of the parties to make the record where they disagreed with each other, and of course, where they disagreed with the Commission's ultimate decision as to the scope of the Oil and Gas Act. So I'm not sure that I see what else we could do or how a rehearing here would actually add to meaningful judicial review. I think that we have done, certainly I'll just say again, acknowledging that we are all human and fallible, we've certainly tried our best and we've certainly all in good faith tried to build as meaningful of a record as possible. Now, certainly Commission Counsel, you're welcome to weigh in if you feel like there are issues as to procedural issues or anything that might prevent meaningful judicial review that we should reconsider. I'll turn to Commission Counsel if you would like to weigh in. I'm seeing the Commission Counsel does not wish to weigh in. At the end of the day, I think the parties disagree with certain. The commission had to make decisions, right? And the parties are not all in agreement here. And the commission did our best to document why and how we made the decisions that we made. Looking at the record that was here, it seems to me that there is plenty for fulsome judicial review, should any party wish to exercise that right. So I am not inclined at this point to take up the rehearing application from IPNM. Is there any further debate?
Not on my end, Mr. Chair, unless Dr. Ampoma has something to add. I would move to reject or deny IPNM's motion to rehear.
Mr. Chair, second.
Moved and seconded. Any objection from commissioners? Hearing no objection. The motion passes. I will turn to Namoga for Namoga's application.
Hi, good morning, Mr. Chair, Commissioners, Madam Hearing Officer, and rest of the parties. My name is Miguel Suazo. I represent Namoga. I'm with the law firm Beatty Wozniak. I'd like to kind of build based upon the Commissioner's comments in response to IPNM's request for rehearing. I think Namoga certainly respects the limited time and resources that everybody has, particularly the commission, and that this has been quite a significant undertaking. And I think, industry certainly appreciates the time and effort that has gone into this, and our application for rehearing hopefully is received as nothing more than an effort for us to be as clear as possible in a complex rulemaking that we already know is going to require numerous guidance types of documents on a going forward basis, just to understand, what these rules actually demand of the parties required to abide by them. Now, as someone who traffics in the dark arts of OCD rules and regulations daily, I can tell you it's challenging even when the black letter law is as clear as, our forebears made it. And it's pretty often that I go back to look at old orders and try and decide what they mean under the circumstances. And so, Commissioner Bloom, I appreciate your comments just now in response to IPNM, and I think you hit on a lot of the issues. And I think for me, that really focuses what the ask here is. Namoga's not arguing that the commission can never incorporate a party's proposed findings or reasoning. I think that the problem is what happens when the commission incorporates, applicants' filings and then materially changes applicants' proposed result. And there's just a reference to those things that, is somewhat clear, but, I'd hate to go back and look at this order 3 years from now when it's an issue for whatever reason and not have those clearly laid out in the order itself and then have to go back to the docket and find, the section of the applicant's closing documents where this actually applies. And just to call your attention to, the code 1915-313C of NMAC requires the commission's order to include the reasons for the action taken. And so Welkin applicants pointed to anti-stacking and say that the order explains that modification and that this is just one example that Namoga's reasoning and argument lacks merit. We actually agree with that example. We agree that the order explains anti-stacking, but that's not actually one of the reasoning gaps we identified. Just to give another example, the existence of reasoning for one modification does not answer the absence of explanation on, for example, section 72-14, which are the factors, which I can get into subsequently, but I wanted to start here. So I might be a little discombobulated compared to, what I intended. But I do think that in the context of what you guys have raised for us today, kind of jumping around a little bit matters. So it doesn't answer the absence or explanation of, the surety market capacity, implementation feasibility. Were those in the record? Yes, but it's not apparent from the reasons or the order necessarily. And as long as we've been, pursuing this rulemaking over 2 years, as Commissioner Bloom pointed out, since 2024, I prefer to measure twice and cut once and make sure that the final order is as robust and the reasoning is as clear and comprehensive as it can be. And so, we did find some examples, if the commission wants examples of conflicts created through incorporation. One example is applicant supported different treatment of TA wells than the treatment ultimately adopted by the commission. The commission adopted a broader variance concept than applicants had originally supported. Another example is the commission accepted industry anti-stacking principles that are inconsistent with portions of the incorporated rationale, and applicants treated transfer as an unavailable solution to financial assurance burdens, while the final transfer rules authorize OCD to deny transfers based on the predicted financial risk. So just to sum up that piece of it, is our point is not that incorporation is forbidden. Our point is that when the incorporated reasoning and the commission's final decision diverge, the order should tell the regulated parties which reasoning governs, because that's helpful in terms of interpreting what is meant within the context of the rule or the subtext of the rule. So Namoga proposes that a revised order identify material incorporated propositions superseded by the commission's modifications, state the commission's governing rationale on disputed provisions, and address principal contrary evidence and alternatives. So I think I've touched on, what I sense the commission might have taken a bit of umbrage over, and understandably, you guys put in a lot of work and time here, and so did we. And so I respect the commission sticking to its position, but I'm here to advocate for my client. And I think that their position has some things that are worth considering as well. As a threshold issue, applicants and OCD allege that some of our allegations are moot because they were previously litigated. Nemoga's arguments were raised in the joint motion to dismiss, in our closing brief, and other prior submissions. And so they characterize those rehearing re-arguments as matters already rejected, and ultimately call Nemoga's request unripe or moot. The fact that an issue was previously raised is not a reason that it is moot, especially in this circumstance. It is why the issue is properly preserved and now properly presented to the commission on rehearing. Nemoga is not contending that the commission never heard these arguments. In fact, quite the opposite. We documented their preservation in the motion to dismiss, the closing briefs, the record that was supplemented, and the record itself. But for the commission today, the relevant question is actually, did the commission resolve those issues in the final order and final rule package? And does the order adequately explain that resolution? And it's our position that the commission's final action was not identical to the proposal that existed when the motion to dismiss was denied. And we think that because after that ruling, the parties engaged in 16 post-hearing negotiations, which for better or worse are not really documented outside of the joint stipulation. Applicants filed exhibits 89 and 90. The commission adopted some of industry's counter proposals. It rejected others. It modified applicants' rule change. It incorporated applicants' reasoning subject to those modifications. So, I raise all those things because saying we previously rejected that argument doesn't necessarily answer how the argument applies to the final rule that emerged months later. So prior litigation establishes preservation, but it does not make an adverse final ruling moot. So on this point, the relief Nemoga requests is to consider the issues on the merits, which I know in certain instances the commission feels it does. And we also ask not to reject the application simply because the legal theories originated earlier in this proceeding. I would like to touch just a little bit on 70-2-14, and I think the most straightforward statutory question in Nemoga's application concerns the legislature's instructions. The statute does not merely say that plugging cost is generally relevant. It actually directs consideration of specific factors, including the depth of the well involved, the length of time, the cost of plugging similar wells, and other relevant factors. And Commissioner Ampoma did a good job of raising that in terms of what he took away from what was presented during the hearing. But in this instance, Nemoga's question is, I think, pretty simple and straightforward, is where within the findings and the final order does the commission explain how those factors support the same $150,000 amount across the materially different well populations that are now governing that amount? Welk and OCD said that those factors were considered, and we know that 150,000 is linked to OCD's cost to plug. I guess in taking a step back from that, I think that restates the conclusion, but it doesn't answer the specific statutory question. An aggregate OCD plugging cost figure does not, in and of itself or alone, explain how the depth was considered, how production history was considered, what constitutes a similar well, why a shallow productive well and a materially different inactive or TA well receive the same amount, or why the same amount applies to a productive well swept into the portfolio provision because of the status of other wells. So I think that's an important distinction, because Nemoga's position is that the statute requires a factor-based determination that is tied to characteristics of the well involved and comparable wells. But our view is that the order does not show how the commission moved from those mandatory factors to a single uniform statewide number for these materially different categories. And and this is again jumping around and apologies, but we just raised in your comments that 150,000 is less than OCD's average cost. Namoga's response to that is that may explain why the 150,000 was selected as a policy number, but it doesn't answer the statutory question of how the commission considered the factors, the depth, time since production, and so on and so forth. And I think the most important thing here, and this is where, to Commissioner Chang's point, reasonable minds can agree to disagree. It's our position that the legislature specified those factors. And Namoga is asking the commission to explain how they informed that 150,000 number. We know it's in the record, but in its statement of reasons and in its final order, because I think that matters for those of us who are going to have to advise on how to comply with these rules on a going forward basis.
Thank you. Ms. Tripp, would you like to weigh in on Mr. Suazo's application?
Thank you, Chair. Just noting for the record that IPNM has joined in Namoga's application for rehearing and supports those reasons, but I don't need to elaborate. Thank you.
Thank you. Welk.
Again, we filed jointly with the division in our responses, and if it's okay with him, I'd defer to Mr. Hall to start with this one.
Mr. Hall.
Thank you, Mr. Chair. Generally, we've had a lot of hearings here. It's a voluminous record. The record makes abundantly clear that y'all were, if anything, above and beyond in your consideration and explanations of the positions the commission took in the order. The order itself is very clear on the basis for the findings in the order. It adopts the applicant's rules and analysis in many ways, but it doesn't in every case. And Commissioner Bloom, I thought very eloquently went through very specifically many examples where that wasn't the case. The order itself clearly indicates where the applicant's suggestions were modified, where they were modified and how they were modified and why. The reasons are stated in the order itself. I noticed Namoga kind of specifically talking about the statutory factors considering the statutory factors and indicating that the commission didn't do that. The commission did. The commission cites to the applicant's closing statement, which I would direct the commission to page 8 of that, wherein, and I'm just going to quote Welk here, Namoga misses the mark again. Applicants produce substantial evidence of the 150,000 one well FA amount is based on statutory factors, including OCD's cost to plug, which I don't have a citation here, but I believe both Mr. Sporich and Mr. Ezel agreed that that's what it should, and that's what the clear statutory language said it should be based on. It's not industry costs, because bonding really has no nexus to industry costs. It's when the taxpayers and OCD ends up holding the bag and being required to plug a well. That's what bonding, that's the logical nexus to that. And I recall Mr. Powell saying, yes, depth is considered in this, but it's not the factor that is most important and most indicative of where bonding should be, and that's the actual cost to OCD. So I thought all three of y'all commissioners, in response to IPNM's application for rehearing, eloquently stated the reasons for the order, why you believe IPNM, and we would urge the same analysis for Namoga, why their application should be denied. And I think y'all's effort in effort and thoroughness in providing not only your adoption of the rules, but the reasons for that are clear, both in the evidentiary, or both in the reporter's record and the order itself. And thank you all for your additional consideration here today.
Thank you, Oxy.
Oxy is keeping a neutral position and just monitoring. Thank you.
Oh, well, sorry, you did. Want to
Yeah,
weigh in?
just wanted to let Mr. Nikiel weigh in if he had anything.
Mr.
Yeah,
Knight?
thank you. Yes, Matt Nikiel here on behalf of applicants. And I'll be very brief. Would just support OCD's summary there, and also just only say that to the point the chair made earlier, it's not clear to us exactly what how a rehearing would add further clarity to the existing clarity that exists in the commission's order and reasons for that order. Again, NMOGA raises many of the same arguments that they brought up throughout the hearing, and in their application for rehearing don't provide compelling reasons for how the commission's final rulemaking order should change the ultimate outcome of those legal determinations that the commission made. So again, we support the OCD's response here, and would again request that the commission deny NMOGA's application for rehearing. Thank you.
Any other parties, EOG, New Energy Economy, anyone? Going once, going twice? Okay. I'll move to commissioner questions then, before I know there might be some statements, but I'll start with any questions. Any questions? I have questions.
Oh, yeah, I did have one, but you can, no, I do have one quick question. So a quick question for NMOGA is, you raising a concern about surety capacity. I just want you to elaborate on this a little bit. I mean, was this something that was really discussed extensively during the hearing?
So it was raised during the hearing, and my recollection across the various witnesses, including the letter that was struck by the commission, was essentially that changing the market to these heightened bonding requirements would cause that market to dry up. We identified that there is a small group of surety companies available generally, and the New Mexico market is already relatively unattractive compared to other market type of environment. So I think the concern is that the financial assurance requirements would be heightened, and that would create more demand for the product, and there would be less market participants able and willing to serve that market if these rules aren't carefully calibrated. Does that answer your question, Dr. Ampoma? Yes.
Now, another question is, so throughout the whole hearing, you saw the evidence from the applicant showing, they analyzed almost all the wells that are in OCD's database, proving to the commission that in their analysis, they considered the age of the well, the depth of the well, all the categories that was in the list that the commission needed to consider. And they were able to touch on each of them. I mean, I went back and forth with them because, I mean, as an engineer, that is what I want to see. Now, they went through that thorough analysis and still got to the point that they believe that it has to be 150,000, considering the cost that OCD will more or less need to plug the wells, considering all those factors. Now, did you believe that NMOGA really did a good job countering that? even NIMOGA presenting evidence to the commission about how the depth, how those parameters contributed to even any amount that NIMOGA was proposing.
So I guess I take exception to the characterization of what we did and didn't provide. If you recall, we had two expert witnesses, both of them petroleum engineers with significant plugging and abandonment experience. And they presented all the various factors that go into assessing, what a plugging circumstance warrants. To a degree, Dr. Mpoma, I kind of think that's beside the point a little bit here. The real issue is, the statutory is the ultimate authority, right? The legislature spoke, and that is what they directed the commission to follow. $150,000 was originated from, the LFC report and OCD's average cost to plug. So this is a policy decision here, and now it's fixed and it escalates. But that still doesn't answer the statutory mandate or question of how the commission, this commission, in this proceeding, considered depth, time since production, and cost of plugging similar wells. And to be clear, I need to make very clear, is that in the record? Yes. Is that apparent based upon what's in the order? I think it could be clearer, and I think it should be, because the legislature itself specified those factors, and all NIMOGA is asking is that the commission explain how they inform themselves of that number in the statement of reasons and in the order itself. If you guys think it's clear, which you might, then I guess that's what you think. We disagree. We think there should be more substantive information there, and I think that'll just make this rulemaking in the record that we've spent 2 years working on, and now we're at the about to exhaust the administration of this rulemaking today, theoretically. We just want this to be as easy to abide by as people who have to deal with these rules, day in, day out. Welk's going to walk away from this, and they're going to be glad these rules are passed, and we're the ones who are stuck with them, figuring out what they mean and don't mean for as long as we can see down the road.
Thank you. Let me weigh in with a couple of questions, and I want to walk through. You may find this helpful to pull up page 25 of your application with the specific reliefs that you're asking for, Mr. Suazo, or at least your client is asking for. I'm trying to see if, I'm not sure that the commission is, I haven't heard from the other commissioners, but I'm willing to consider limited. So I'm trying to walk through your various requests here, A through N, and try to figure out what parts of this we can grant you relief on, or what parts of it would actually be effective to grant relief on through a rehearing, if any. I think we heard from Commission Counsel last time, and Commission Counsel's welcome to weigh in again, that clerical errors can be resolved without granting a rehearing, scrivener's errors. So if and this might be a question for Commission Counsel and Commission Clerk as well, but it looks like request for relief B here is the same request that we discussed last time that IPNM, I believe, raised in their response to Welk's application for rehearing, right? Where there was a line or a clause mistakenly left in that didn't comport between the proposed final rules and the order. I believe we resolved that because Commission Counsel went back and reviewed the tapes, looked through the transcript, and resolved that that one of them was a clerical error. Can I confirm that with you?
Correct.
Okay. So I think at the very minimum, the relief that you're asking for is B. You'll be able to obtain whether or not we actually go all the way to a full hearing or a rehearing, limited or otherwise. Okay. want to double check. Has the cross-reference, so let me go back up to A. Was that a cross-reference error that was otherwise also identified and also that the commission also discussed during the during the consideration of Welk's application for rehearing?
No, I don't think that issue on A has yet been resolved. But if I might phone a friend here, if Ms. Tripp has that more readily available and has a view on that, I would appreciate some insight there as well, just in case I'm missing something. But it's my understanding that's still something that needs correction.
Okay. We can certainly look into resolving any clerical errors if they're truly clerical, and we're happy to review any transcripts and records to make sure that whatever is captured is accurate and that there are no, and that we resolve any remaining clerical or scrivener's errors. So I'll put a question mark on A and come back to it. Ms. Tripp, take your time, but if you can advise, we're certainly, yeah. Okay. On C, in my view, and I'll take the views of my fellow commissioners, but that is the crux of the rulemaking where the commission was called on to make a determination. And I think Commissioner Mpoma's question that the dialogue we just had with Commissioner Mpoma is that at least Commissioner Mpoma felt that the mandatory factors were inherently considered as part of the way that the applicants in OCD arrived at $150,000. Of course, whether that is sufficient whether that is sufficient consideration as part of the mandate from the Oil and Gas Act, I think the parties have disagreed, and the commission has had to take a position on that. I'm not sure that rehashing that here at this forum is going to lead to any further clarity for a reviewing court who ultimately would be looking at our homework on that. And then so let me move on to so D, same. It's a legal interpretation question, and I'm not sure how a rehearing. I mean, I understand obviously a rehearing would allow the parties to make the arguments again, but it feels like we've, at least to me, that was. I'll just say that it has been discussed and the parties have fought about it, and the commission has been asked to make a decision on it. E, reconsider and remove. So again, legal interpretation question that the parties fought over, that the parties briefed, and the commission has already weighed. I'm not sure, other than if rehashing at this forum, whether that would only muddle the record for a reviewing court, or whether that actually would clarify and facilitate more effective judicial review. As to the joint stipulation waiver, I think the parties' joint stipulation speaks for itself. The parties were clear in their filings as to what the stipulation does and doesn't do, and certainly I don't think the commission would. I'm not sure a rehearing would change what the joint stipulation does or doesn't do. The joint stipulation speaks for itself, and to the extent that any of us up here on the dais misstated the effect of the joint stipulation, I think Welk's filing points out that we tried to clarify the record and clarify any misstatements, and try to recognize that we understood that the joint stipulation speaks for itself and that it stands for what it does stand for. G again calls for legal. I mean, it's a legal dispute again as to the scope and the breadth of what we're authorized to do, and the commission has again taken briefing on that, taken commission counsel advice on that, heard from all the interested, or at least given every single interested party an opportunity to weigh in on those things, and we've had to take a position and make a decision, which again, I'm not sure if rehashing that is going to, whether it's merely going to muddy the waters and muddy the record for a reviewing court, or whether it would actually grant the relief here of trying to make things clearer for a reviewing authority. H, similarly, I mean, surely the constitutional due process and and due process concerns and federalism issues apply, and and anything that the commission does would be within those boundaries as to where, to the extent that reasonable minds disagree with the boundaries of those concerns. Again, it seems to me that that is a question that the commission trying to rehash is going to be less effective than letting the record speak for itself on judicial review. As for the surety letter, again, we relied on both, if I recall correctly, that wasn't just, we relied on both commission counsel's advice on that, as well as our hearing officer's advice on that. The granting a rehearing, I don't know that we would be able to change. I don't know that we're in a position to change our decision on that particular item of evidence. J and K. These I'll turn to commission counsel. I remember we had an L. So the three items, J, K, and L, asking for a more detailed order, laying out the commission's reasonings and its thinking. I remember commission counsel and I had a conversation about the sufficiency of using some, as Mr. Suazo has acknowledged, that sometimes adopting parts of proposed language from parties is reasonable and effective. So I guess I'll turn to commission counsel and see if he has any advice on whether he feels the order as drafted is insufficient to address the issues raised in J, K, and L.
Mr. Chair, my job is to provide options, and one option is you feel like it's sufficient, and the other option is you feel like it's insufficient.
Okay, I will turn to my fellow commissioners then. I will note that in going through the proposed order with the that we did specifically, I did ask my fellow commissioners to specifically consider it paragraph by paragraph, and we did specifically exclude paragraphs that are no longer applicable because the commission went in a different direction than what the applicants had urged, which by the close of the hearing, the applicants' proposals had also already changed by incorporating certain changes from the negotiations that happened, including input from OCC. So let me turn to my fellow commissioners and ask about JKNL and how they feel about those three requested relief items.
Mr. Chair, I believe that our order does cover these areas identified by JKNL. Just to refresh people's memory, the order that the commission issued states, quote, "The commission adopts and incorporates applicants' notice of filing, closing argument, and proposed statement of reasons," end quote, as its own findings of fact and conclusions of law and its own reasons for the action taken. Actually, that's where the end quote would be. And as you mentioned, we went through those paragraph by paragraph. I believe we had a break in the deliberations, maybe a night, to go back and see where we had made some changes and would have departed from the applicant's closing arguments and statements of reasons. So your memory is correct there. And that was tailored specifically to take those changes into account. I've been, I guess this is my 8th or 9th year, or 7th year on the commission. There was another term back in the 2012, 2013, 2014 when I was doing this as well. And there are times when the commission will write out its own findings of facts and conclusions of law and draft them and not base them on what one party has done. But in this case, the OCC, us commissioners, we came down, we found that the applicants in the OCD's case largely prevailed. Had it been IPNM or NMOGA prevailing, then we would have, so heavily we would have used their statements of reasons as our statements of facts and conclusion of laws. So, I think we did cover these areas sufficiently.
Mr. Chair, I do support the submission of Commissioner Bloom on this. I do believe that we did try our best to incorporate even materials from other parties, not necessarily adapting 100% of the applicant's reasonings. So I'm not sure if we are to reopening the case here, how much we can really add to it. Thank you.
Oh, and Mr. Chair, if I might, just on I, where we had a letter arrive too late to be included in the evidentiary portion of the proceeding. I believe it came in after we had closed the evidentiary hearing. And we actually spent a significant amount of time discussing that with the hearing officer and asking Mr. Chandler for his views on that. And really, we're giving it seems like we're giving it extra weight that the letter showed, that it was a letter. But had it been any person that showed up and we were gone, they would not have been able to give their testimony. I think this is. I don't even know, in a sense, if we excluded this letter from becoming part of the evidentiary hearing, more than we, excluded anyone that showed up after we'd left the building. So I don't think that really bears or would be a basis for opening rehearing or that it deserves much consideration at all. Thank you.
Did you? Thank you. I appreciate that. Commissioner Bloom, did you have I know you had other thoughts and questions and, or like, I know you had thoughts, so I want to make sure I turn to you and if you have any further thoughts.
Mr. Chair, were you able to finish your review of? Yeah, okay.
I think M is moot at this point because we didn't dispose of it at the August 6th special meeting because today is the 13th, right? So M is functionally already granted one way or the other. So, so I don't really have anything else. That's I've reached the end of the list here at this point.
Thank you, Mr. Chair.
Mr. Chair, could we go back to A? Because I think we pinned down what the issues are.
Sure.
So, and Ms. Tripp, feel free to jump in. As I understand it, the cross-reference in Part 25 needs to be updated to show that TA wells from 0 to 2 years still receive active well bonding versus those over 2 years get inactive well bonding.
Mr. Chair and Council, Ann Tripp on behalf of IPNM, that's correct. So the site is 1915-2514E in the proposed rule amendments, and it's located on page 16 of 17. And the specific cross-reference we're requesting, and I can share my screen if easier.
If you wouldn't mind, Ms. Tripp, I think if you would share your screen, that would be helpful.
Okay, so I've highlighted subsection D here under Part E. I'll scroll up a little bit so we get your bearings there. And so the request for the correction to the proposed rule would be to insert subsection D is now subsection F, but there should also be reference to subsection C to incorporate the temporary abandoned status wells in years 0 through 2 that still remain eligible under the active well, either single or blanket bonding. So the request would be that the sentence reads, the division shall not approve a permit for approved temporary abandonment until the operator provides financial assurance for the well that complies with subsection C or F of 1915-8-9 NMA C.
I'm looking at that, Mr. Chair, and yeah, I believe D would be, yeah, did you say low producing wells, Ms. Tripp? That's where it's pointing to now? As written?
Commissioner Bloom, I believe that's correct because I think subsection D in the current rules prior to amendment references temporary abandoned wells.
I'm not able to determine if that was a substantive oversight or whether that is a clerical error at this point, whether or not that I will let the other parties, do you wish to weigh in on whether a very short rehearing, very limited rehearing on this particular issue is warranted so that we all have time to figure out whether this is a substantive error that needs to be corrected on the record or whether this is merely clerical?
Commission Chair, my sense is that a rehearing on this is probably not necessary, that if the record is clear on the commission's intent and the evidence around this, and that if a correction is indeed needed, that would just simply be a clerical correction that we would be comfortable with.
Okay.
I guess if you're asking positions of the parties, I mean, I think the nomenclature of whether it's for clerical or substantive, is kind of immaterial as long as it's, accurate as the final result. So, if that warrants limited rehearing for that purpose, I think nomenclature is less material than accuracy, but I do think that this needs to be addressed however the commission deems best to address it.
Sure. Fair enough. I'm just trying to figure out whether a limited rehearing might be the vehicle for us to get there, or whether or not this fits with it. Because if it's a substantive oversight and we need to lay out some additional record for whatever changes, then I want to make sure we do that so we don't have any procedural irregularities, and that we have the maximum clarity. But I will leave it to. I'll let other commissioners weigh in.
Mr. Chair, might I suggest a short recess, and then if we can point to a place in the record where you guys address this that would make it a clerical type of error fix, would that help you all out?
I'm more than happy to do that if parties are willing to guide us and give us room to do that. Sure.
Okay. Sure. Well, then if you guys, would like to take a recess, we're glad to try and find that in the record, and we can reconvene in 10 or 15 minutes, I suppose.
Okay. Commissioner Bloom, did you want to go through any of your further comments at this time, or would you be okay with a recess now?
No, I think we could recess now, and perhaps we come back at 11 or 19 minutes, 18 minutes.
Yeah. Does 11 o'clock work for everybody? Okay.
Yes.
Hearing no objection, we're in recess until 11. Thank you all so much. Good morning. The time is just after 11 o'clock, so I will call the meeting back to order. We were discussing NMOGA's requests for relief A. Mr. Suazo?
Yes, Ms. Tripp and our associate Carrie Buffa were able to track down where in the order and in the record this was referenced. And I think Ms. Tripp has the document ready to share on the screen, and then we can walk you through that.
Okay. Ms. Tripp, go ahead.
Thank you, Chair. Yes, let me pull that up for everyone to see. All right, so I'm actually going to start at the existing rule so that you have a quick reference for the language. This is at currently it's identified at 1915-2513, and you can see subsection E there. The division shall not approve a permit for or approve temporary abandonment until the operator provides financial assurance for the well. That complies with subsection D of 1915-8.9. Looking now to the proposed rule amendment. Sorry, here we go. That language appears identical in the proposed rules, which is page 16 of 17 at now 15-25-14 Part E here. And the reasons that IPNM and NMOGA would argue that this is a clerical correction and as acknowledged by the commissioners in the last hearing, which was corrected. This was the disparity between the rules or the rulemaking order and statement of reasons that this is Part B, subsection 4. It's located at page 5 of the rulemaking order. And I've highlighted the grounds that would support the commission's decision in striking that last sentence, which was inadvertently included in the rule amendment language. But the reasoning being where they pointed to Commissioner Ampoma's concerns regarding the risk for operators seeking to place wells and approve temporary abandonment status for a short period of time. That is at Part B4, subsection 3 of the rulemaking order. And that's confirmed at the very top of page 6 here that the commission's selection of a one-time 2-year period for TA wells, between TA year 0 and TA year 2, being referenced in section 70-2-14 of the Oil and Gas Act. And so it would be our position, going back to the current proposed rule language here, that subsection D is a holdover referencing the prior rule. And so it should be updated to read subsection C or F. And I can go up to those parts as well. Part 1915-8.9, this is at page 7 of the proposed rule amendments, which covers the financial assurance for well plugging, C being active wells, and F being right now wells that are in approved temporary abandoned status, inactive wells, and wells that are expired temporarily abandoned status.
Other parties wish to weigh in? Or
I would just like to
Suazo?
point out that the transcript site for this is from the October 25th, 2025 transcript, pages 502 through 504. And I don't know if we have ready access to that, and I'm not sure it matters, but that is where Dr. Ampoma indicated support for NMOGA and IPNM's argument that TA wells in approved status need to remain eligible for active well blanket bonding for the first 2 years.
Thank you. Did other parties wish to weigh in?
Yeah, this is Kyle Tisdale on behalf of applicants, and apologies to the commission. We're sort of working through this on the fly right now. Based on our quick read, I think NMOGA's suggestion here in Part A of their request for relief is sort of, and I think the fix is overbroad perhaps to what the commission intended. So looking to the language again of 1915-2514E, that is intended to just ensure that the financial assurance is in place. when the division grants or were to grant a well to be in a TA status, right? And so D, if you go to then 1915-8-9D, that is for low producing wells, and there's a lot of testimony on that front. Now, I think the question becomes, there is an exception that the commission granted, right, for wells that are moving, and Chair Chang, you went through the effort of identifying in your demonstrative exhibit there the sort of subsection of category that would apply for that TA exception, and that is wells that were active moving into directly from active moving into TA status, correct? And so I think the response here is not to get rid of D in the language, because that still applies to most of the wells in TA status. Those are wells that are inactive or have been inactive and moving into TA status. Those would still be required to have that enhanced 150 single well blanket bond. But I think the answer is that to Namoga's point and to Ms. Tripp's point would be to maybe add subsection A to that language so that it's A and D rather than just D. I think that is my best reading of what's going on here.
I'm seeing on the screen here that Ms. Tripp does not quite agree. But before I go back to you, Ms. Tripp, can I just ask if other parties want to weigh in on this one?
I think this is a helpful discussion on the substance of it. I wanted to clarify that A in Namoga's application, which has some language, it references Part 4B, which calls the commission's order arbitrary and capricious. I just want to be sure we're not discussing it in that framework. It's sort of multifarious and has many subparts. I think what the rule should say is certainly a good conversation. I just want to be sure the commissioner's not agreeing with Namoga's position that it's arbitrary and capricious, or that $250,000, to the extent it is saying $250,000 blanket bond is somehow a cap on the rule's ability to require single well bonding. So little zoom out sort of concerns from OCD there. Thank you.
And I want to apologize. I think I misspoke when I said A and D. What I should have said was C and D. C is the provision for active wells, and D is the provision for low producing wells. So I think I said A because that was what Namoga's request for relief was, but I think the actual language would be the insertion of C, the availability of active well bonding for that, just that subset caught by the exception, the TA exception that the commission carved out.
Okay. Ms. Tripp, I'm seeing you being slightly less concerned now that we're no longer talking about subpart A or A. Yeah.
Yes, thank you, Chair. And I think I can speak very briefly to Mr. Hall's point there. When I referenced Part B4, that was Part B, subsection 4, subsections 1, 3, and 4 of the rulemaking order, not of Namoga's application for rehearing. I would agree that subsection A generally covers applicability. I think the fix here, the applicant's suggestion that the fix is subsection C or D was rejected last week when you addressed this specific issue on wells and temporary abandoned status from 0 to 2 years. And the problem, I think, that just procedurally, when you're operating under 1915-2514, that is when an operator is applying for approved temporary abandoned status. And so at that point, if the well has not been in, obviously the well's not in TA status from 0 to 2, D may or may not apply, but most certainly C, it's an active well prior to that. And so one option would be to strike the subsection reference from 1915-2514 and just make it that the well complies with the financial assurance required under 1915-8-9. And that leaves it more open to application, because as the charts have established and the procedures about whether, avoiding stacking, a well could be in any kind of combination of conditions, which might create a different financial assurance requirement.
Thank you. At this point, it seems to me that at the very minimum, whether or not it was a clerical error, the parties at least are not quite of uniform mind as to what the best fix is. So I'm leaning towards granting a very limited rehearing on just this particular subsection. But go ahead.
I think actually would be welcome to hear from OCD on this front as well. I think Ms. Tripp's suggestion is actually maybe the correct one, is that if we just eliminate the with subsection D language in that provision, it references all of 1915-8-9 to just make sure that the appropriate financial assurance is in place upon that TA application. I think that actually covers it, and I think we would be comfortable with that change.
I concur. I think that would allow the entire rule to be analyzed in each particular factual pattern to determine the proper financial assurance on a fact-specific basis. So I share. I think we would also agree with Ms. Tripp's suggestion to just make the entire rule applicable as opposed to that subsection in that part.
Okay. I mean, if there's unanimous consent, there's a lot of power in unanimous consent, right? So I'll welcome other parties to weigh in, but Ms. Tripp, just so that the record is clear, would you mind pulling up the section again and highlighting the language so that we're all on the same page and there's a visual record forever on YouTube of precisely the change that we're talking, I guess we're calling it a clerical edit here if all parties are amenable to that.
Yes, Chair. So you should be seeing page 16 of 17 of the proposed final rule amendments. And that was entered by the Commission on July 16th, 2026 at part 1915-2514E. I believe the suggestion and the agreement of the parties would be to strike. So the sentence would read, the division shall not approve a permit for approved temporary abandonment until the operator provides financial assurance for the well that complies with 1915-8.9, striking the words with subsection D and of from the existing proposed rule amendment.
I will pause for a moment to let all the parties review that and digest that.
I think with probably needs to stay in the language, but subsection D of, if that were eliminated, I think that is what Ms. Tripp is maybe suggesting. And what applicants would be comfortable with.
OCD concurs with Wilk's statement.
So the way it looks now on the screen, just for clarity of record, we're striking the words subsection D of, right? Okay. Mr. Suazo?
Yes, that's acceptable to Namoga.
Oxy?
Can you give me a moment?
Please,
Thank
take your time. In the meantime, I'll also invite all the other parties to review this. Ms. Tripp, do you mind I know you already struck it through, but since there's so many strike-throughs, do you mind just highlighting that in some sort of bright, bold, or exciting color?
Yes, I can do that.
Thank you. if any other parties are with us and on the line, EOG or State Land Office, New Energy Economy, if anybody would like to weigh in, you're welcome to do so as well. Ms. Vance, are you waiting for your client or?
Yes, Oxy, no issue from Oxy.
Well, if that's the case and everybody agrees that this is this is the clerical change as reflected on the screen here in front of us, any objections from commissioners if we were to make that change or correction?
No.
I think that looks appropriate, Mr. Chair. Thank you.
Okay. Okay. Did you have other comments on whether or not to open for rehearing more broadly? Commissioner Bloom?
Sure, yes. I did want to address some of the comments that NMOGA made in its application. To rehear, I have seen that there is a request for clarity for reasons, a request for reasons to be given for our action. So I do want to take a little bit of time. I have less comments than I did with respect to IPA&M's motion for hearing. Of course, some of the issues that NMOGA addressed were also addressed by IPA&M, and I'm not going to repeat all of that. But NMOGA begins by asking, quote, saying rehearing is warranted because the proposed final rules contain clerical errors, end quote. We got through some of those last week and we got through one just now. So I appreciate NMOGA having flagged that, and then we could all work through these items successfully. NMOGA goes on to request or say that, quote, rehearing is warranted because the proposed final rules impose financial assurance obligations on active wells outside the statutory blanket bond framework, end quote. This was addressed multiple times throughout the hearing, in the applicant's closings and in its deliberations. I know I looked at it at one point at NMSA 70-2-14. We do not see limiting language regarding the creation of other bonding categories. So that statute says, quote, the Oil Conservation Division shall establish categories of financial assurances after notice and hearing. It doesn't say establish only 3 categories of financial assurance. There's multiple opportunities in that in that statute where that kind of language could have been inserted, and it had not been. It was not. So I believe this rulemaking is on solid footing there. Next, NMOGA brings up again is the commission on solid ground when adopting a new financial assurance amount of $150,000 without addressing the mandatory statutory factors. Dr. Mpoma talked about that earlier today. We've gone on quite a bit there as well. Number 4, again, NMOGA is asking that we rehear this based on the insertion of low producing wells and high risk portfolio financial assurance categories, stating that they were not authorized by the Oil and Gas Act. And once again, I would look at that statute, NMSA 70-2-14, and see that there's nothing that would prevent us from creating those categories in which the applicants put in front of us. And I believe, again, that the OCC is on solid ground there. NMOGA's fifth statement is that rehearing is warranted because the proposed final rules use change of operator provisions to regulate or condition private transactions without clear statutory authority. We gave that significant discussion during the hearing, during deliberations. The legislature clearly gave the OCD the power to regulate well transfer, and it does so currently. This says nothing about the private transactions. It simply says, will the OCD, or how will the OCD approve well transfer in the future going forward? Mr. Powell spoke to this as well during the hearing. NMOGA then goes on to restate some of the hearing examiner report questions to us, what's the so-called major questions. And these were along the lines of, does the passage of HB 80 following the hearing require the recalibration of the reasonably pay standard under the Oil and Gas Act? And we said no, that we went into that at some length as well. I guess I don't think I'll repeat that here, but we were firmly on record going through those questions that the hearing examiner put in front of us. And then wrapping up, again, we see NMOGA asking, quote, the commission adopted some of applicants' reasoning, modified portions of the proposed rules, accepted certain industry counter proposals, rejected others, admitted others, end quote. It goes on. Again, there was a strong record created. I spoke to that a little bit earlier here today. We said that, quote, the commission adopts and incorporates the applicant's notice of filing, closing argument, and proposed statement of reasons, its own findings of fact, conclusion of law, and its own reasons for the action taken, end quote. So I think we went over that as well. We addressed the letter that arrived late from the SFAA. And it got here after the end of the evidentiary hearing, and so it was not admissible. The same as if somebody had come up to the door and we'd concluded and gone home. So for those reasons, I'd be ready to offer a motion to deny rehearing.
Any further discussions?
No.
I'll take the motion.
And so, Mr. Chair, I move to deny NMOGA's application for rehearing.
Second.
Okay, moved and seconded. Is there any contrary votes from the, or any objections from commissioners? Without objection from the commissioners, the motion passes. Thank you all for participating today, and those, to the extent that there've been any clerical errors identified throughout any of the three motions for rehearing, the commission clerk will make sure that we address the corrections. Thank you all very much. I will move on to other business at this time. I'm not aware of any other business other than going into, well, yeah, other than what's not already on the agenda. Okay. I think there's a note to let everybody know that the next meeting is the OCC regular meeting on September 10th of 2026. It may have been inadvertently advertised as a special meeting on a preliminary agenda, but it is the regular meeting on September 10th. And then the last item on our agenda, we're functionally going to adjourn for everybody else and go into a closed session to get some litigation updates with our commission counsel.
Need a motion, a second, and a roll call.
Go ahead.
Mr. Chair, I move to go into closed session to get a litigation status update.
Seconded.
Any votes to the contrary? Without objection, We're heading into closed session to discuss litigation involving the OCC. Thank you all.